Hello, everyone, and welcome to our compliance update. I'm Alonzo Martinez, Associate Counsel Compliance at HireRight, and this is our 2019 year in review from pot to bots. As a reminder, today's webinar is being presented for informational purposes only. It's not intended as legal or compliance advice, but I hope that you'll take today's discussion as talking points for you to raise with your teams and your legal counsel. Here are a few housekeeping items before we begin. So during this webinar, please take the conversation to Twitter using the hashtag HireRightWebinar. In order to receive HRCI or SHRM credit, you must attend the full live session of this webinar, and credit information will be emailed after the webinar. We're not providing a copy of today's slides. However, we will send you an email shortly with the link to a recording of this webinar session. If you are experiencing any audio or visual issues, please refresh the browser window by clicking F5 on your keyboard, or send us a message using the Q&A icon at the bottom of your screen. Lindsay is producing today's webinar and will be monitoring the feed for any technical issues. After the presentation, we'd appreciate getting your feedback. Please take our brief survey and let us know if the session was helpful. We want to create sessions that are meaningful, so we welcome ideas for future topics. So take a couple of minutes and let us know what you think with that survey. All right, in this installment of our It's the Law Now series, we're going to talk about some familiar topics like ban the box and pay equity laws, but we're also going to cover some new legislation that dominated the 2019 legislative year, including marijuana reform, which is pot, and artificial intelligence, which are bots. Let's get into the rundown for today. So if you've attended some of our previous quarterly compliance webinars, you'll see that what we're covering today is a lot more ground than usual. And that's because I really wanted to give you a quick recap of significant issues that developed over the course of the year that I really thought you should be aware of. So since we have so much to cover, I'm not going to cover any one topic in a lot of detail, but I'll give you some highlights to consider as they relate to your screening program. Okay, so like I mentioned, we're going to start with familiar topics like ban the box, and then talk about clean slate laws, laws that affect an employer's use of credit reports, talk about new pay equity legislation, and then get into a discussion of what I consider emerging topics like marijuana reform, cover a few significant case law updates, talk about data privacy measures, quickly cover the very interesting world of artificial intelligence, and then wrap with a quick conversation of what else we should expect in the rest of 2020. And remember, if you have any questions during this webinar, use the Q&A icon at the bottom of your screen. Lindsay's monitoring questions, and I'll try and cover those at the end. Okay, we have a lot to cover, so let's get started. And let's kick things off with ban the box. So just a reminder, ban the box measures delay when an employer can inquire into a candidate's criminal history. In some cases, they may also include special notice requirements and may also limit the types of criminal information that an employer can consider when making their suitability decision. This is the adjudication process. And here's a look at the current landscape of ban the box jurisdictions impacting private employers. So on your screen, you can see that there are 34 that have been passed. The jurisdictions that you see in red on your screen are new measures that were passed in 2019. So if you've attended any of my previous webinars, you know that I like to reinforce the fact that not all ban the box laws are created equal. Again, at their most basic, in all the ban the box jurisdictions, you generally can't ask a candidate if they've ever been convicted of a crime during the initial application or request a criminal background check until some later point in the vetting process. But there's also some jurisdictions that require special handling. I want to spend just a few seconds to remind you of your compliance obligations. So on your screen, you're going to see those in the red column that require that you identify the candidate's specific criminal conduct that may disqualify them from hire as part of the pre-adverse process. That's potentially disqualifying criminal conduct. Then there are those in the teal column that require that you conduct and provide an individualized assessment that describes the job relatedness of the candidate's criminal conduct as part of the pre-adverse process. So that's teal. And then in blue, New York City and San Francisco shown shown on your screen in blue, you need to provide additional city-provided notices or forms as part of the pre-adverse process. Remember that you need to manage your processes outside of the typical pre-adverse and adverse action processes, so you definitely can't create a one-size-fits-all approach to compliance in these jurisdictions. At a minimum, you're going to need to make sure that your program bakes into considerations the compliance requirements that we talked about in these jurisdictions. So we do have a solution to help you comply with ban-the-box measures, and that's Compliance Workbench. What Compliance Workbench does is it flags background reports subject to ban-the-box laws based on work location or the place of residence, and it allows you to create a template for an individualized assessment or to provide a notice of criminal conduct and send them out as part of the pre-adverse process through the HireRight system. So Compliance Workbench really identifies those relevant ban-the-box laws and gives you the ability to handle those ban-the-box laws and stay compliant with those various ban-the-box ordinances. So if you want to learn more about Compliance Workbench, you can do so by reaching out to your account manager or salesperson or contact customer service. And I understand that some of you are having some trouble displaying or seeing the display. I'm going to move to the next slide. Hopefully that will clear up the issue for you, maybe some latency issues with this webinar. So I'm going to quickly run through some of the new ban-the-box measures, just a few highlights, starting with Westchester County, New York. Their ban-the-box law became effective in March 2019. So what I want to point out is that while New York State does not have a ban-the-box measure in effect, it does require that all employers in the state conduct an Article 23A analysis when assessing a candidate's criminal history. So what's an Article 23A analysis? Well, the Article 23A analysis is an individualized assessment, which means that you'd assess the candidate's criminal history and look at any evidence of rehabilitation or reform, things like holding similar jobs or good professional references. You'd also want to consider how long ago the conviction occurred. Focusing specifically on Westchester's law, just like what's required in the state of New York, an Article 23A individualized analysis has to be provided to the candidate upon their request. And moving on to New Mexico. New Mexico's ban-the-box measure became effective on June 14th of 2019. What I want to point out about New Mexico's law is that it's a little different. It prohibits private employers from inquiring into a candidate's arrest or conviction history as part of the initial employment application and upon discussion with the candidate. So that's the key here, upon discussion with the candidate. So in New Mexico, you're required to have a discussion with the candidate if you want to inquire into their criminal history, which means that you actually have to engage your candidate in a dialogue concerning your criminal inquiry. So think about that. That's another step that you're going to need to build into your process when you're hiring into New Mexico, that specific dialogue or engagement in a conversation. I also want to point out that New Mexico's law permits disqualification based on an employer's policy, so that's a little bit different. So remember, though, if you do have a criminal conviction assessment policy, which most of us does, that policy cannot be discriminatory, meaning that you're going to want to bounce your policy against the EEOC's 2012 guidance to employers on the use of arrest and conviction history and consideration, and take that into consideration. So really, you want to make sure that you're not hiring in a discriminatory manner, but New Mexico does give you the ability to disqualify an individual based on your policy. It's an interesting carve-out in that state. Okay, and here is Colorado's ban-the-box law. All I want to point out is that it scales. You can see there in the coverage section, applicant employee, that initially applies to only employers with 11 or more employees, but then come next year in 2021, it applies to all applicants for employment. That's the only real relevant thing that I want to point out of Colorado's ban-the-box law. And moving on to Waterloo, Iowa's new law, that became effective on October 7th. Waterloo's new law applies to organizations that employ 15 or more within the city of Waterloo. So you can see there on your screen that employers are prohibited from making an adverse hiring decision based on arrests or pending charges, records that have been expunged, or to make an adverse hiring decision based on an applicant's criminal record without a legitimate business reason. So what's a legitimate business reason under Waterloo's law? So legitimate business reasons would include situations where the criminal conduct has a, quote, substantial bearing on the candidate's ability to perform the responsibilities of the position. Also situations where employment would cause unreasonable risk of substantial harm to property or the public, or business reputation or assets, as well as positions working with children or other vulnerable populations. So a couple of quick caveats. One is that HireRight does not report records of arrest or charges that did not result in a conviction. But I think the practical takeaway here is that if you're conducting a criminal background check for a candidate who will work in Waterloo, you need to assess the candidate's criminal history before potentially withdrawing the candidate's offer. Again, you don't have to provide an individualized assessment to the candidate, but I would most certainly suggest that you document it as part of your adjudication process and take into consideration the definitions of legitimate business interests that are provided to you within the Waterloo ban the box measure. And finally, here's the newest ban the box law, Grand Rapids, Michigan. This one came up relatively quietly. It was passed and became effective in December. And there's nothing particularly different about Grand Rapids' new law, but I did want to point out that it applies to an individual who performs lawful work. So that's an interesting carve out, right? An individual who performs lawful work. That means it could apply to independent contractors as well. So as you think about ban the box laws in general, that's an important distinction that you need to consider with respect to your own ban the box compliance and the reach of a ban the box law. When you're reviewing ban the box laws, you want to review the definition of employment or employee in that statute, and that generally lets you know if those measures are applicable to independent contractors. Let me know in the survey if you'd be interested in an overview of ban the box measures and their applicability to independent contractors or maybe the gig economy in general. All right. So that is it for ban the box. Let's move into clean slate laws now. And clean slate laws generally provide that certain minor convictions can be expunged or sealed if a specific conviction is met. So the processes for getting these convictions expunged or sealed, they differ by state. Some are automatic and some require the ex-offender to petition the court for that sealing or expungement of their record. So what you can see on your screen are the states that have passed laws that permit the sealing or expungement of certain adult convictions. So quick sidebar, there are many more states that permit the sealing of juvenile court records, but I'm not going to talk about those since HireRight doesn't report convictions that occurred in a juvenile court. We're only concerned with those records that appear in an adult court. So as you can see on your screen, the majority of states have a clean slate law. Those are the states that are indicated in dark blue on your screen, with the states in yellow being those that had new or enhanced measures passed in 2019. Okay. So let's take a closer look at some of the new new clean slate laws. At the bottom of the screen here, you're going to see a summary of the new or enhanced measures that were passed in 2019. So taking a quick look at those, in Nevada and Hawaii, you'll see that most minor marijuana offenses can be expunged or sealed if the ex-offender petitions the court. And then in West Virginia, Pennsylvania, and Vermont, most nonviolent misdemeanors can be expunged or sealed. What's really interesting and groundbreaking, really, is that Pennsylvania is automatically sealing nonviolent convictions of people who have spent 10 or more years without reoffending. So they are the first state in the nation to automatically seal nonviolent convictions. And it's estimated that some 30 million records will be sealed within 2020 alone. So that's a huge difference there. So what does this mean for you practically? Well, I think the biggest impact to you is that you won't see, obviously, certain convictions reported in states that have clean slate laws. The biggest impact, of course, will come from screening candidates with criminal histories in Pennsylvania. Again, some 30 million records will disappear as of the end of this year. And also remember that if you ask candidates to self-disclose their criminal histories, a candidate in a clean slate law, a candidate in a clean slate state who has had their criminal history sealed or expunged can then lawfully state that they were never convicted of that crime. That's a pretty big difference, especially if you're using a tool like applicant self-reported information within the HireRight system. Okay. Let's move on and talk about states that restrict an employer's access or consideration of a candidate's credit history. And that's what you see on your screen. The states in red all have laws that restrict an employer's access to a candidate or employee's credit report. So in most cases, access to credit is limited to certain circumstances listed within the statute. Generally, that's limited to individuals who handle money or who are in management positions, individuals who control the course or the direction of the business. But then in some cases, like California, you have to provide the candidate with a notice that specifically identifies the reason for requesting their credit report. There are other states like Colorado, for instance, that have specific adverse action requirements. There's really a lot to cover regarding credit. Let me know if you'd like me to host a brief webinar on this point, being that you need to be aware of the fact that there are additional compliance requirements outside of the standard background check process. So we haven't seen a lot of movement in the credit check space, but on your screen you can see Puerto Rico highlighted. In 2019, Puerto Rico did add a credit use limitation law. So we will cover that now. You can see on your screen, Puerto Rico prohibits employers from refusing to hire someone as a result of their credit history, requesting that individual's credit history, or otherwise taking adverse action based on an individual's credit history. And there are limited exceptions, which you can see on your screen. I'm not going to read those out for you, but if you invoke one of those exceptions, you still need to get an individual's express written consent to request that credit check. So again, if you can invoke an exception under Puerto Rico's law and you are requesting an individual's credit check, you do have to get their express written consent. We do have a white paper available at the HireRight Resource Library that addresses discriminatory hiring practices with respect to credit. So if you do have questions about that, please be sure to check out the resource library and download our white paper. Moving on to pay equity. This is going to be a brief conversation. Remember that pay equity measures look to promote equal pay for equal work and will often include a salary history ban. A salary history ban is a ban on asking a candidate about their former compensation until some later point in the hiring process. So here's a look at jurisdictions with effective salary history bans. All of the jurisdictions on the left side of your screen are jurisdictions with existing measures in place. So I've broken those out by state and city. And then on the right side of your screen, you're going to see new measures that have or will become effective in 2020. So again, in all of these jurisdictions, it's impermissible to ask about or verify former compensation until some later point in the hiring process. There's not much more for me to say here other than there's going to be a growing trend on these salary history bans. So expect a growing trend to eliminate the what did you make in your last job question. And really my question to you is what value are you getting from asking individuals about their former compensation? Normally you're already presenting a negotiated offer, so it's really an irrelevant question. Even if a salary history ban isn't in place, you might consider eliminating the salary history question from your pre-hire process. And the one thing that I want to add is you may consider also conducting a pay equity analysis in 2020. In some states, such as Colorado, if you conduct a pay equity analysis, and what I mean is looking at all of your positions and assessing any discrepancies in pay inequities based on sex, or in some cases other factors like race or gender, age, and correcting those pay inequities. If you correct those pay inequities, you can help provide a defense against a future pay discrimination lawsuit. So it's a good idea to conduct a pay equity analysis. We've also covered a lot of information on pay equity at our resource library. So again, check that out if you have an opportunity. All right, and moving on to marijuana. So here is our medical marijuana map, and that's available at the resource library as well. So there are 35 states, including Washington, D.C., with medical marijuana laws on the books. Looking at your screen, you'll see states in yellow, which are where accommodation of marijuana use is required, states in dark blue, where there is no likely need to accommodate, states in bright blue, where the regulation is silent, and states in light gray that haven't passed a medical marijuana law. So there have been updates to the law in New Jersey, New Mexico, Illinois, New York City, and Nevada, all of which we'll talk about today. And just to be clear, when I talk about accommodation, I mean that states that require accommodation means that you can't discriminate against an individual just because they're a lawful marijuana user. And more specifically, as it relates to your workplace, reasonable accommodation means that you ensure that the employee has the appropriate medical certification, meaning that they hold a medical marijuana license or card. But always remember that you can request that they refrain from on-duty use or otherwise not pose a risk in your workplace. Of course, the big caveat here is that there's exceptions for individuals in certain safety-sensitive positions. Okay, and here's our recreational map. All states in the various shades of blue on your screen have decriminalized recreational marijuana. You'll see that recreational marijuana continues to creep towards the Midwest, with Illinois being our newest state added to the map. Maine is highlighted here in light blue because there is the need for employer accommodation of recreational marijuana. Maine is the only state in the nation where you can't impact a recreational marijuana user's employment for lawful off-duty conduct. So granted, if you employ individuals in safety-sensitive or other regulated positions like transportation or health care, you may be able to disqualify an individual for a positive test in Maine, but it's unlikely you'll be able to do so otherwise. So again, in Maine, you'll likely need to accommodate recreational marijuana use unless the candidate or employee is in a safety-sensitive or regulated position. And here's a quick summary of the new laws passed in 2019. Again, we're going to focus on the practical effect to your screening program. So New Mexico, top of your screen, jumps on the trend that prohibits employers from adversely affecting an individual's employment based on their lawful use of marijuana. So again, you can't adversely affect an individual's employment based on their lawful use of marijuana in New Mexico. And in New Jersey, there are new procedures in place if an employee or candidate tests positive for marijuana. So a few different steps you'll have to go through. First, you have to give written notice to the employee of the positive test. Secondly, that notice has to inform the employee of his or her right to, quote, present a legitimate medical explanation for the positive test. And third, the employee has 3 working days from receipt of the written notice to submit information to the employer to explain the positive test result. The employee may also request a retest at their own expense. And as part of his or her explanation for the positive test, the employee may present a doctor's authorization to use medical marijuana or proof of registration under the New Jersey medical marijuana law. So these are all considerations that you will have to take into, all issues that you'll have to take into consideration if you test for marijuana in New Jersey. And in Illinois, we have the legalization of recreational marijuana. But remember that Illinois law does not prohibit pre-employment testing for marijuana, and nothing in the law prohibits employers from adopting reasonable zero tolerance or drug-free workplace policies. I get this question a lot. For some reason, there seems to be a misunderstanding that individuals cannot be tested for marijuana in Illinois anymore, and that's not the case. Looking at Nevada, you can no longer adversely affect someone's employment because they test positive for marijuana unless they're in a safety-sensitive position. While the law doesn't specifically say that you can't test for marijuana in Nevada, we're starting to see a lot of clients move away from marijuana testing since you can't adjudicate a positive result. So if you can't adjudicate a positive result, why test? That's kind of the logic there. And finally, we have New York City. New York City's law is arguably the most progressive of the lot. Effective May 2020, you will not be able to conduct pre-employment testing for marijuana in New York City unless the worker is in a safety-sensitive position as defined by New York City's law. So that's not to say that you can't conduct post-employment marijuana testing if you find it valuable for your screening program, but you most certainly cannot conduct pre-employment testing. So again, think about modifying your policies and processes to address drug testing and marijuana testing specifically in Maine, New Mexico, Nevada, and New York City, as they all have certain restrictions with respect to marijuana testing or adjudication. Another plug for the resource library, we have several recorded webinars hosted both by myself and Dr. Simo, and white papers, all of which cover marijuana laws. Okay, so let's quickly cover a few cases that made headlines in 2019, and we're going to stick with our marijuana theme. So I just want to drive home a couple of points with these cases, starting with the Chance case. With the Chance case, Chance was a lawful medical marijuana user in the state of Delaware. He was involved in the workplace incident. Kraft Heinz tried to make the defense, and I'm quickly summarizing here, that since federal law supersedes state law, specifically since marijuana is federally illegal, that they didn't need to accommodate marijuana use, despite state law, Delaware's law, that does require medical marijuana accommodation. So this goes to trial, and the court doesn't buy this argument and holds against Kraft Heinz. So why does Chance win here? Well, Chance wins because Delaware's medical marijuana law requires that employers accommodate workers who use medical marijuana lawfully off-duty and off-premises. So the court said that saying that federal law preempts state law in this case would negate the entire purpose for Delaware passing this accommodation law. We've seen this become a trend. We're seeing more and more cases that find exactly this point. So my point here is that you as employers should not fall back on federal preemption as your argument in any states that require accommodation. When we were looking at that medical marijuana map, those are states that are in yellow, which again require accommodation. So you just can't say that because marijuana is federally illegal, you have to prohibit it in any state that requires accommodation. And looking quickly at the Whitmire case, again, Whitmire is a lawful medical marijuana user in Arizona. This is another workplace accident case, although here, Walmart did not request a post-accident drug test until a couple of days after the accident. And of course, Whitmire tests positive for marijuana, and she should test positive since she's a lawful medical marijuana user. And Walmart then terminates her based on that positive test. The problem here, though, is that the drug test occurred 2 days after the accident. So there's no indication that Whitmire was impaired at the time of the accident. So the takeaway here is to make sure that you have a good post-accident drug testing policy and a good reasonable suspicion policy. And remember that no accommodation statute requires that you permit use at work, so you certainly don't have to permit impairment at work. But you do need to make sure that you understand what impairment is. Just having marijuana in your system isn't necessarily indicative of impairment under the law. At least that's what case law is telling us. So this is very much a gray area of the law that we're going to have to keep following, and we're going to have to see where cases lead us with respect to what impairment really is. Moving away from marijuana to what I think was by far the most widely discussed FCRA case of 2019, and that's the Gilbert case, which is on your screen now. I've talked about Gilbert ad nauseum, really more times than I can remember. So I'm going to just say that what was at issue in Gilbert was the compliance of their background check disclosure and authorization forms. And the court in Gilbert reminds us that the text of the FCRA clearly states that the disclosure, the background check disclosure, must be in a document that consists solely of the disclosure. The FCRA also requires a disclosure that's both clear and conspicuous, and California's state law requires the same for disclosures of that state's rights. That's under the Investigative Consumer Reporting Agencies Act in California. And the issue in Gilbert is that the disclosure form used by CheckSmart, which is California check cashing stores on your screen, their disclosure form was a single-page form that combined the FCRA disclosure, the California disclosure, and other states' disclosure. So what Gilbert tells us is basically it reiterates the FCRA's position that the FCRA disclosure must be a standalone document, the California disclosure must appear on its own, and any additional state disclosure should clearly identify who they are relevant to. So practically speaking, as it applies to your screening program, that means if you're using a single-page disclosure and authorization form, you should immediately scrap that form and ensure that you're aligned with the FCRA's requirements and the requirements of other state laws. Remember, at minimum, providing a standalone FCRA disclosure and providing a California disclosure for California applicants that resides on its own. Okay, on to our next topic, 2 quick hits on data privacy laws. Starting with the California Consumer Protection Act, or CCPA. The CCPA covers for-profit businesses who meet any of the following thresholds. That's gross revenue that exceeds $25 million, or entities that buy, receive, sell, or share personal information of 50,000 or more consumers, or derives 50% or more of their annual revenue from selling personal information. Remember that businesses do not have to be located in California for the CCPA to apply. But what's really important here as it relates to the CCPA is AB 1355, which you can see on your screen. And what AB 1355 did is it says that any activities conducted in accordance with the Fair Credit Reporting Act are exempted from the scope of the CCPA. So what that means is background checks requested through a consumer reporting agency like HireRight are not subject to handling under the CCPA. But that doesn't mean that you as employers are off the hook from needing to comply with the CCPA in some way, shape, or form. So remember that under the CCPA, employees are considered consumers that must be afforded certain rights. So specifically, the CCPA requires mandatory privacy notices and disclosures about the data collected by employers and the purpose for collection. So as of January 1st of this year, you need to make sure that you have employee privacy notices that disclose the categories of personal information that the company has collected and the purposes for which personal information will be used. So again, this is outside of your background check program. Background check activities are exempted by AB 1355, but separately for the collection of any employee data, you must have employee privacy notices that discuss the categories of personal information collected and how you're using that information. Moving from the West Coast to the East Coast, I'm going to drop a couple of quick notes on the New York SHIELD Act. The SHIELD Act is the Stop Hacks and Improve Electronic Data Security Act. This goes into effect in March of this year. And this new law broadens the state's existing breach notification law. And it also imposes new security obligations on companies that do business in New York. So the SHIELD Act applies not only to consumer information, but also to employee information. And it applies to any business that maintains private information of New York applicants, or if your business has at least one employee in New York State. So again, these are additional obligations with respect to data handling of employee and applicant data in New York State. So what this means is that employers need to be aware of the information that you're collecting from employees and your candidates. You need to assess how you're safeguarding that information, how long you're keeping it, and most importantly, you need to have response plans in place in the event that there is a data breach. Just like with any other data privacy measure, you're going to need to work with your information security teams to assess the implications of New York's SHIELD Act. Okay. Now let's talk about another area of the law that is quickly evolving, and that's worker classification. With the gig economy becoming an increasing player in the workforce, we're seeing more and more laws addressing who is and who is not an independent contractor and what rights certain types of workers should have. Going back to California, here's California's AB 5. So under AB 5, there is a three-prong ABC test that's used to determine worker classification. And under the ABC test, all workers are first presumed to be employees. So they're not independent contractors, they're immediately and expressly employees. So the burden is on the business to demonstrate that this individual is actually not an independent contractor by applying the ABC test. And all three prongs of the ABC test must be met. So if a worker only satisfies one or two of the prongs, then the test isn't met and that doesn't cut it. So a worker can only be classified as an independent contractor if A, the worker is free from control and direction in the performance of services, and B, the worker is performing work outside of the usual course of the business of the hiring company, and C, the worker is customarily engaged in an independently established trade, occupation, or business. So AB 5 makes the ABC test the law in California, and it also expands its application to all provisions under California's labor and unemployment insurance codes. So there's a multitude of businesses and professions that are exempt from AB 5. Way too many to cover here. In fact, I think it's over 50 professions or types of businesses that are exempt. A quick example is doctors, dentists, insurance agents, lawyers, real estate agents, variety of creative professionals. All of these individuals are not subject to the ABC test, but otherwise you do need to consider that ABC test. So my recommendation here is to invest time and effort into looking at your organization's use of independent contractors and run the ABC test. Remember, if a worker doesn't meet all three prongs, A, B, and C, then they're considered a traditional employee under California's laws. And you'll need to change your processes and policies to treat them as such. And if you're not a California employer, take heed, because I think that this ABC test will become very popular as introduced legislation in other jurisdictions. And here's a new law in New York City. This really wasn't widely reported. It was a really subtle but significant change to the New York City human rights law. The law has been clarified to note that anti-discrimination protections are now extended to independent contractors. So what I think is particularly relevant as this applies to your screening program is that we now clearly know that independent contractors are covered by the city's anti-discrimination laws. So you'll remember that New York City has a ban-the-box law and a Fair Chance Act that requires that you provide a copy of their individualized assessment of their criminal history under New York Article 23A. And you have to do that on the city's prescribed individualized assessment form. So what this means is if you're not currently conducting that Article 23A individualized assessment and providing a copy of the form to your independent contractors, you'll need to do so now because, again, all independent contractors in New York City are now afforded anti-discrimination rights, meaning, again, you need to provide that Article 23A individualized assessment form to independent contractors for any of your New York City candidates. All right, and let's wrap up our discussion here with bots, artificial intelligence. Hiring managers, recruiters are increasingly using sophisticated artificial intelligence solutions to streamline large parts of the hiring process. AI tools can scrape job boards and evaluate applications to identify the best candidate for your organization. We also know AI tools can stage online interviews. They can scan everything from the candidate's word choice to their facial expressions before they recommend the most qualified candidate to you as an employer. So there's a recognition that these AI laws need to be assessed and also need to be regulated. And that's what we're seeing in Illinois. So here's the first law in the United States that directly addresses artificial intelligence in the hiring process. That's the Artificial Intelligence Video Interview Act. It took effect on January 1st of this year. So the act requires employers to obtain consent from applicants before using artificial intelligence to evaluate the applicant's video interview and qualifications for the position. So there's a few things that you have to do. You have to provide consent, and that consent must notify each applicant before the interview that artificial intelligence may be used to analyze their video interview and fitness for the position. You have to explain how artificial intelligence works and the characteristics it uses to evaluate applicants. You have to obtain the candidate's consent in order to use the AI solution. All of this must be done as part of the process prior to using any AI solution with respect to video interviews. So what happens if the candidate doesn't consent to a video interview that uses artificial intelligence? Unfortunately, Illinois law doesn't tell us what to do, but I think as a best practice, you'd probably want an alternate process in place to accommodate the candidate. So maybe an in-person interview or a phone interview, maybe even something like a FaceTime or Zoom meeting or other type of interview that doesn't directly involve artificial intelligence. And remember that if you're using a recorded interview with AI as one of the first steps in your recruiting process, so this is pre-offer, you'll need to find somewhere to provide this disclosure and receive authorization for the use of AI. So that most likely makes sense as part of your ATS or early on in your application process. Okay. So as we start to wind down today's webinar, let's move away from what transpired in 2019 and talk about what we can expect the rest of 2020 to look like. So here's what's on our radar, starting with artificial intelligence. Both at the federal and state level, there's a number of bills under consideration. The majority of the bills are what I consider exploratory or fact-finding measures. These are laws intended to form committees or other bodies of individuals to assess how the use of AI will affect our daily lives. So at the federal level, this includes bills like the Algorithmic Accountability Act. So the Algorithmic Accountability Act would regulate the use of AI and similar AI platforms, and it would require users of AI to audit the AI solution for its impact on accuracy, fairness, bias, discrimination, privacy, and security, and then correct any issues introduced by that AI solution. At the state level, we have California that's introduced resolution number 125. That's the Bias and Discrimination in Hiring Reduction Through New Technology Act. And what resolution 125 does is it urges lawmakers to promote the use of new technologies, including AI, to eliminate bias and discrimination. I think we're going to talk about AI a lot more over the course of the year, as it's really a controversial issue, and there are several states that are considering AI measures. On the one hand, you have proponents that say AI can reduce bias in hiring, and on the other hand, you have critics that say that AI introduces bias into hiring. So this is a really interesting area of the law that I think we as employers are going to have to pay close attention to. Lawmakers are really all over the map with respect to where they stand on AI. So my suggestion is that if you're using AI in any way, shape, or form, you want to create an AI policy and you want to consider being transparent to your candidates and employees with respect to the use of AI. You may also want to consider drafting a disclosure and consent document that addresses your use of AI. And remember that if you are going to produce a disclosure and consent document, that AI disclosure and consent document should be separate from your federal background check disclosure and authorization. In a similar vein to AI, I think laws concerning biometrics collections will start to pick up steam in 2020. And when I talk about biometrics collections, I'm talking about gathering fingerprints or iris or retina scans or voice scans. So we already have Illinois and their Biometric Information Protection Act. That requires that you provide notice concerning the collection of biometrics, let the individual know how the biometrics are going to be used and retained, and requires their consent before collecting and using their biometrics. I think we're going to see Illinois law as a model for other states' biometrics laws. Kind of on the other end of the spectrum, there's laws like New York's SHIELD Act that we talked about earlier. This contains specific breach notification requirements if biometric data is exposed. So again, practically speaking, if fingerprint data is exposed, you have to have a certain process to follow for that breach notification. So we're talking about two different approaches to biometrics laws here. There's the proactive approach like Illinois that requires disclosure and consent, and then there's the reactive approach like New York, which requires notification if something goes wrong. Only time will tell where other states will land. My recommendation is that if you're collecting biometrics like fingerprints, for instance, that you have a policy that addresses their use and retention, and that you consider providing disclosures and obtaining consents concerning their use. Now looking at data privacy. Much like California's Consumer Protection Act, I'm certain that we'll see other states starting to bolster laws for collecting and using an individual's data. Again, comparing and contrasting existing laws, we see California's law that requires disclosure and express consent for most uses of personal data, as well as access and delegation rights. And then we have other states like New York that are prescriptive in that they detail how data should be handled and maintained, but they're also reactive with respect to breach notification. If I had to guess, I think we're going to see more legislation on par with California's law, but again, we're just going to have to wait and see. So my recommendation here is to continue to assess how you collect and use data, how long you retain data, see if you can minimize the amount of data that you collect and retain, and create publicly posted policies. By that I mean policies on your website that address your collection, use, and retention of data. And most importantly, be prepared to respond to access and deletion requests that might burble up in the future depending on how laws come to fruition. You're absolutely going to have to do this in 2021 if you are subject to CCPA. So again, you will need to be able to provide access to your employees and candidates access to their data, as well as the ability to delete data in some cases in California in 2021. So ask yourself, if you need to do this, can you do it? Can you remove it from your system if necessary? All things that you need to think about with respect to data privacy. Okay, worker classification. What we saw in California with the ABC test, and then we saw New York City expanding anti-discrimination measures to independent contractors. I think we're going to see more of this. We're tracking several bills, including one major bill at the federal level. That's the Gig Workers Act. It establishes a test for establishing worker classification. Granted, it has been in committee since March of 2019, so I'm not sure it's going to pass the finish line, but it is out there, and we're tracking a number of other bills at the state level that concern worker classification. So my recommendation is to take stock at your independent contractors, recognize that you may not be able to fall on the position that they, because they signed an independent contractor agreement, they are independent contractors. Again, you might have to conduct the ABC test to figure out where they land. So that's something that you may want to do now. Most importantly, I think be poised to make changes to your use of independent contractors depending on where the law lands and what your organization can absorb cost-wise from a labor and benefits perspective, right? If these individuals were originally independent contractors but are now being considered employees for the purposes of things like overtime and unemployment and other benefits, it's something that you may have to reconsider. Okay, we're going to wrap with marijuana reform, and this is a super simple discussion. In the last 2 years, we've seen more and more states pass laws that require employer accommodation of lawful marijuana users in non-safety sensitive positions, meaning that an employer must permit lawful off-premises and off-duty use. I think we're going to continue to see this progression, and as these laws continue to progress, I think we're going to see a slower progression towards laws that prohibit employers from taking adverse action against lawful marijuana users. But I still think that they're going to advance. I wouldn't be surprised if we see this trickle over to the West Coast in the next year or two. So think of maybe pre-employment bans on marijuana testing coming to maybe California, Washington, or Oregon. Don't know that it's going to happen, but it's entirely possible. So the recommendation here is simple. Make sure that you're complying with the laws of the states that restrict marijuana testing or adjudication, and prepare for more to come down the pike. And at the bottom of the screen is a reference to an article that I wrote that was published in Forbes a few weeks ago, where you can learn more about our trends for 2020. Speaking of which, here's a shameless plug for some other resources we make available. Take a few minutes to check out the resource library and blog, and catch up with us on Forbes and LinkedIn. We put a lot of effort into creating quality content for you, so really take advantage of that. And that is everything that I have prepared for today. So let's open it up for questions. Please use the Q&A widget at the bottom of your screen to type your question. For those questions we're unable to answer today, we'll follow up with you after the webinar. And remember to take our survey at the end of this webinar. Your feedback helps to shape future webinar topics. Personally, I really want to make sure that I'm producing content that you find beneficial. So let me just give it a second here so that I can take a look at some questions. Okay, so questions regarding ban the box. It looks like there's confusion regarding whether ban the box depends on place of residence or prospective place of employment. So the answer there is it depends. Some measures specifically outline whether it is residence or place of work. Other measures are silent. I think to the best of your ability, it would behoove you to try and comply with both. So if there is a ban the box measure in the place where somebody works, but not where they reside, for instance, if you can apply the more stringent measure there and take the place that they work into consideration, then I would most certainly do that. Unfortunately, there's no real clear indication of where things should land with respect to ban the box measures. So again, I think the safest route to compliance is taking both place of work and place of residence into consideration, if at all possible. Question about Colorado. If you're not incorporated in Colorado, does the ban the box law still apply to you? Again, it applies if you have a certain number of employees operating in Colorado, so effective in 2021. If you have one or more employee in Colorado, then the ban the box measure does apply to you. If I have a candidate who will work in a location where there's no ban the box requirement, but they are interviewing a candidate who is in a ban the box jurisdiction, what should they do? Again, my vote would be take the ban the box jurisdiction into consideration, especially if the law in that particular jurisdiction requests that you specifically look at it. A lot of confusion regarding New York Article 23A. So let's just do a quick recap on that. Remember that New York State does not have a ban the box measure in effect, but all employers in the state of New York need to provide their candidates with a notice of their rights under Article 23A before requesting a criminal background. Then you have to conduct an Article 23A analysis when you're assessing that candidate's criminal history. So again, the Article 23A assessment is really an individualized assessment. It means that you'd assess the time that's passed since the conviction, the age of the candidate at the time of the offense, any evidence of rehabilitation and good conduct, the seriousness of the conviction, the job responsibilities, and if the offense has any bearing on the candidate's ability to perform the job. So you have to conduct this analysis anytime a background report returns criminal history for an applicant for a position in New York. So anyone in New York, if a criminal background returns any results, you need to conduct the Article 23A analysis. You don't necessarily have to provide that analysis to that candidate unless it's requested. But then we have some cities in New York that do have ban the box laws. That's Buffalo, Rochester, Westchester County, there are all ban-the-box requirements. And then in New York City, there's a ban-the-box requirement as well. And in New York City, you specifically have to provide the Article 23A analysis to all candidates anytime there is a hit on their criminal history. So a little bit of a nuanced situation there. Let's take a look. A lot of questions with respect to New York City's pre-employment ban on marijuana. Are there any workarounds to pre-employment drug screening in New York City after May 2020? The answer is not necessarily. My recommendation to you would be to set up a screening package for New York City candidates where you exclude marijuana from your pre-employment drug testing panel. You would then only screen individuals who would not receive marijuana screening within that specific package or account. So that is most certainly a difference in the process that you'll have to consider. Similar questions regarding Maine, Nevada, New Mexico, and their marijuana laws. So again, remember that Maine, Nevada, New Mexico don't necessarily ban pre-employment testing for marijuana. In all three, you cannot adversely affect an individual's employment because they test positive for marijuana unless they are in a safety-sensitive position. Remember, in Maine, that's true for recreational marijuana, and in Nevada and New Mexico, that's true for medical marijuana. So what we see is some employers that choose to continue to test for marijuana in these jurisdictions, and others that choose to remove marijuana from their drug testing panels in Maine, Nevada, New Mexico, because they can't ultimately adjudicate a positive result. We have really, really risk-averse customers that would rather not even see the result because they can't take action on the result. Questions about New York's Article 23A and its applicability to New Jersey candidates. The answer is no. That would only be applicable to a New York candidate. Let's see. Questions about the New York City Commission on Human Rights Article 23A analysis form. So that's available on their website. So if you do a web search for New York City Human Rights Article 23A analysis, you'll find that form. If you can't find it on there, we do, I believe, make it available in our compliance workbench packet, which should be available in Screening Manager. Confusion regarding preemption of marijuana law at the federal and state level. So my point there was that if a state has passed a medical marijuana accommodation requirement, so if the state says that you have to accommodate a medical marijuana user, then you must do exactly that. We have seen employers that say that they're not going to accommodate marijuana use because it is federally illegal. Now, in a state that has a medical marijuana accommodation statute, I would not fall back on that argument that marijuana is federally illegal because we see case law that says that states that pass accommodation statutes do so for a reason, and that is to provide accommodation to lawful medical marijuana users, and therefore employers must accommodate that marijuana use. Okay. So we are starting to run a little short on time, so I think what we'll do is wrap up here. If I did not get to your question today, we will make sure and get back to you over the next few days. And with that, I'd like to thank you all for your time again today. I hope that you found today's conversation helpful and that it gave you something to think about and act upon regarding laws and litigation, as well as our glimpse into the rest of 2020. Speaking of which, join us for our next quarterly compliance update, which we'll produce likely in April, and we'll dive into some new laws affecting employers then. Until then, thank you again for joining. Please complete the webinar survey, and we'll talk again in the spring.